Yeah! You know who it is. Hey, don't ask who did it. Check the name, fool. The associates did it, yeah, they rolling deep. The associates did it, got it out the streets. The associates did it, never miss a beat. If you heard some real ones, it was probably me.
Hey everyone, this is episode 6 of The Associates Did It. My name is Todd Cohen. I am here today with James Metcalf, Andrew Vaughn, and a new podcast guest, Mr. Bradley Rivers. Today's subject matter is legal myths people still believe. We're going to run through a variety of different scenarios that we commonly hear from clients and discuss our thoughts on whether they're accurate or not.
I'm going to take a wild guess. If it's on Google, it's definitely accurate.
Yeah, right.
That's step one. If you found it on Google, it can't be wrong. Isn't that right, Brad?
Well, I prefer ChatGPT, but yeah, I think that's fair to say.
Yeah, the amount of ChatGPT responses that we're getting these days could be an entire episode or series itself.
But that's the most annoying part is that people give it to us and they say, here's what I think we should do with the case. And then you read it, you go, ChatGPT has a specific type of look. We can tell you're not being smarter. It doesn't sound better. It just shows so you made a Google form in a PDF. That's all you did. I can't stand it.
That's funny, man. The formatting is very, very specific.
Yeah.
You can tell ChatGPT immediately on glance.
Yeah, run a report. That's how it looks. Yep, every time.
Yeah. Well, let's get started with a few legal myths. Mr. Vaughn, if I sue someone, will I be in court next week?
Absolutely not.
Yes.
No, you won't.
Did I file a TRO?
You still won't be in court next week.
I could be.
But probably not.
Probably not.
Ex parte TRO, maybe. It depends. I mean, I guess it could depend upon what you're talking about, but for the most part, no, you're not going to be in court next week.
Sorry, I realize we're talking lingo between each other. TRO stands for temporary restraining order.
Right.
We know that because we deal with that stuff all the time.
Right. So a temporary restraining order is going to be filed in a family case primarily, and the rule in Texas, at least, is that you have to have a hearing on that within 2 weeks of its issuance. So, I mean, that's close, but not quite. But for the most part, in most cases, you're not going to have any appearance in court until after the defendant on the case has had an opportunity, or respondent has had an opportunity to answer. And Texas law generally gives a respondent or a defendant to the Monday following the expiration of 20 days from the date that they were served to file an answer.
At 10 a.m.
So somewhere,
10 a.m.
Yes.
somewhere between 20 and 26 days, maybe.
Yeah, from the date that they're served. So it's not even from the date that the lawsuit was filed.
Yeah.
Which actually, kind of incidentally, is something that I've noticed happening a lot more on family cases, or divorce cases in particular, is that, we have a 60-day window for the most part where, between filing before the court can issue any sort of final ruling on a divorce case, and then you have the 20-ish day answer period. So a lot of attorneys have started filing the divorce and then just sitting on it for about 40 days and then serving the other side so that the 20 days and the 60 days expires at the same time. They can go in and default them on day 61. So it's
not a bad move.
Yeah, it's sneaky but effective.
Yeah. You can afford the appeal though. It's getting overturned real quick. It's just you follow procedure. It's did you actively follow procedure though? But also, a court probably wouldn't be too happy doing that.
No, there's not necessarily any rules that say that you have to serve the paperwork within a certain period of time after filing.
Oh, I love it.
So I mean, it's
technically,
is it a kind of a crappy sort of thing to do? Yeah, sure,
but not illegal.
It's not illegal, and I don't work for you. I don't work for the opposing party. I work for my client. So therefore, if it serves their interest,
sure. Gamesmanship.
I will say, unfortunately for a lot of people, the only time you might get in court quickly like that, not a week, but maybe within a month, is an eviction.
Yeah.
Because those are sort of supposed to move quickly. So
yeah. Well, so yeah, we've gone through the time period for someone to answer, but even if someone answers, does that mean they'll be in court that week?
No.
Mm-hmm.
No, you still get 20 days, and people get and I mean, we've had clients that, where I have at least, that get mad and like, why would they answer yet? Why would they answer? Like, technically, they don't have to. Why would they not answer early? If I'm them, I wait until the last day too.
Right.
Why give you an extra skip? Because what you don't know, if you don't work in law, is that when they answer, then the next deadline starts for initial disclosures and discovery. Discovery is basically, I hand you documents or I ask you for documents, and that's how it all works out. So if I answer earlier, that timeline comes up earlier.
Right.
But if I answer the exact day I need to, then I can already have that calendar to when discovery would start. Why would I give you a jump on discovery? You're suing me.
Yeah, and that's the way that cases can get drawn out a lot of times. Is you wait to the last day to answer, and then discovery has to be served within a certain amount of time from the answer, but then you have 30 days to respond to the discovery, right. So you wait till the last minute to respond. Mm-hmm. And then if there's any
then there's always issues. So it's to be a
right.
motion to compel coming right after that.
Right, and then you have X number of days to respond to the motion to compel before it gets set for a hearing, and then you got to deal with the court's availability for the hearing, and so yeah. So generally, and even on an eviction, what Bradley was talking about, you still have 10 days to file an answer, yes. on that as the defendant. So even then, you're still probably going to be looking at getting into court, 2 weeks out. So.
Yeah, obviously there are several different areas of law, and we're talking pretty generally at the moment. Within probate, within criminal, within landlord-tenant, the JP realm, all of that has, sort of different.
JP stands for just the P's. It's
yes.
Normal person court, $20,000 or less.
Yeah. Also,
sorry, I know we're talking a bunch of lingo, so I'm making sure those who don't deal in law probably need to know what the heck we're talking about.
Right. Yeah. On the probate side of things, that's one of the I've cited several times to clients or prospective clients on that. The fastest probate that we've ever done was one that I kind of managed for us, where the guy came in actually to the title company that we used to run, and he had a property that he was trying to sell. He had a contract for the sale of the property. He was supposed to close in a month, and we discovered that the house was his mom's. And mom had just died, and so we were like, well, crap. So but there was a will, so it's like, okay, so we filed the application.
If there wasn't, we were going to forge one.
Right. Shut up.
That's a secret.
No. Yeah. Anyway, so there was a will, and we were like, okay, let's we turned around really quickly. We filed the application for probate of the will. We got it posted. There's a 10-day posting requirement for probate, where it has to be posted at the courthouse.
I mean those stack of documents that no one ever looks through?
Or the bulletin board with everything like pinned up on. Like, yeah, exactly.
I had to pin something up before, and I definitely pinned it underneath. So I was like, it's right there.
It doesn't matter as long as it's there, I mean, it's everybody else's responsibility to go flip through stuff. But anyway, so it's a 10-day posting requirement before you can set a hearing, and then you set the hearing and you do your proof up and then all this. So we got that, we filed it, had it posted, set a hearing within a week after the 10 days had expired. So it was like within 3 weeks we had that probate done. He had letters testamentary, and we were clear to sell the house. And so that was
it definitely does not happen that quickly usually.
yeah. Of course, he then did get sued for it being a fraudulent will, but that was a whole other issue.
That's a new assignment.
Yeah.
So how long on average would you say that situation takes normally
in a real probate?
In a not expedited fashion?
Where we're not rushing it, honestly, you should be in court on a probate within 2 to 3 months. I mean, it's not something that should take very long. If it's Dallas County, it might be 5 years. I don't know.
Well, sort of along the lines of procedure and the timelines of a case, let's talk about myth number 2. I can ignore the lawsuit and I'll just handle it later. What happens if you get served with something, Mr. Rivers, and you do not pay attention to it?
Well, most likely you're going to get defaulted. You might be able to handle it later if you're able to get the court to reinstate the case, but that is just problematic in and of itself. So it never pays.
Default is.
Well, a default, so as they mentioned earlier, you have 20 days, or I should say the Monday after the 20th day, to respond to a petition that's filed against you. If you choose not to respond, the plaintiff then has the right to file what we would call a motion for default with the court. And that default basically is the defendant hasn't answered, they've been served properly, and this court should grant judgment in my favor based on their failure to appear and defend themselves. And
So basically, everything I said in that petition is now true.
Right.
Because no one's here to call foul.
exactly.
Right.
And so if they're asking for $50,000, $100,000, more than likely, if they have provided enough evidence to the court to back up that damage request, the court is going to enter judgment against you for that amount.
And sometimes
And-
not. They just take your word for it.
Yes. Sometimes it doesn't even require.
I have been on the receiving end like, you're just
Yes.
going to buy that? All right.
Yeah.
we had a JP. No, it wasn't JP case. Yeah, it was a district court, Dallas County District Court case that was brought to us for collection, where the petitioner had received a default judgment of $42 million against her former landlord.
A lot of repairs now.
Oh, there were so many things. She was sick because of this or that or this other thing, and she, she had filed a petition. She claimed $42 million in damages in the district court. The guy didn't answer, and there was a default judgment signed by an actual judge in a real robe. For $42 million. It was the craziest thing I've seen in my life.
Good luck collecting.
We did send post judgment discovery.
Yeah.
We recently obtained a default judgment for $500,000 for intentional infliction of emotional distress.
Oh my gosh.
Did we really?
We did. We are currently trying to domesticate that judgment. I don't want to get too much into the details, but it's an out-of-state defendant.
Yeah. Todd, that we're doing.
Yeah. But yeah, that's the danger of not responding.
I know.
Now, again, there is a process if you're a defendant. If you genuinely weren't served or somehow didn't get notice of that petition, there is a mechanism. You can file a motion to set aside the default judgment, but you're going to have to prove to the court either that service was somehow improper or that you had some excuse that wasn't just indifference to the petition that would qualify you for setting aside that default. But that's going to be an expensive process, getting a lawyer, and courts are really reluctant to do that. I mean, you're going to have to show quite a bit to get them to say, okay, we'll take
And
this
there's
case
so many
further.
requirements, even from an attorney. Like, they'll let you do it even if it's a simple calendar screw up. Because in reality, no party is really harmed. The damage claimed still exists and just keep going. But I had one here that the person, they tried to do that with an attorney. They just didn't do anything. And they tried to get a motion for new trial. Well, they didn't accompany it with an affidavit. And so I pointed that out to the court. And when I get there, the court starts going a little bit. And I'm figuring like, okay, she's about to have us do, state who you are and who you represent. And then she just started going in because she already knew who I was. And she started going to the other attorney saying, why do you have this? Why do you have that? And I realized you were going down my motion line by line. And the first thing I was taught in litigation when it comes to a hearing like this, if the judge is agreeing with you, shut your mouth. Kind of like if your sister or brothers get in trouble and you start going, ha ha, well, guess what? Now you're in trouble because mom or dad had to focus all on them. But if you keep talking, well, now it's back on you. And I was going to be nice to you, but if you want to keep talking, I guess we'll keep talking.
Right.
Because in that scenario, she said something. I was like, I wanted to object, going, no, because she's not wiggling out of this. Because the judge is basically going, Mr. Metcalf's completely right.
Mm-hmm.
You lose. There's no new trial. You're done. You're out of time. You got to do this. And she had to pay out of her own pocket to pay our clients.
Yeah. I think also, talking about doing like a bill of review or whatever, where you can come in and you can say, hey, I didn't get served, and I just found out about this, and I know that the judgment was 4 years ago, but this is the first I've heard of it, and therefore I think I need to be able to, reopen the case and kind of get out of this. If you have actual knowledge of the suit, then you're probably not going to get that. And we actually had one where the guy was like, I never got served, and they brought affidavits from the process server, where he described in excruciating detail our client exactly, saying, this person came to the door and said, no, that guy's not here.
So you had knowledge.
Yeah, and so
allegedly, no, it's pretty legend.
Right. And so it's like if you if you know that something's going on, you have kind of a duty to check into it.
Well, typically also process servers leave their card behind. So you're like, I didn't want to call them, but you admit you saw the card.
Mm-hmm.
And what does it say? ABC process server. What do you think that meant? I don't know. You think to Google it?
Well, what's kind of interesting to me is how often I feel like all of us probably run into the situation. I mean, how frequently are we all talking to a client and they say, oh yeah, I saw that. I didn't think I had to do anything with that.
Yeah. Some are smart and they call immediately and say, I just got this. I know this is me. No idea what this is about, but I am getting sued. I'm like, all right, perfect timing. And then we'll get some that say, yeah, I got served this or whatever, and I think there's court in a couple of days. Like, oh, all right.
I was just telling someone yesterday, I wished you had, hired us just like 2 weeks ago.
Yeah.
It would have been the perfect time, and right now it's a lot more difficult. And
not impossible, but yeah, it makes it a lot more difficult, and that's typically how the bill gets a little higher because we have to file a lot more things to try to basically cover our own butts and yours at the same time.
Yeah, like if we're starting off at ground level, on a case, that's fine, but if you've already dug yourself a hole and we have to, one, get you to stop digging and two, find a way out, that's when it's going to make it more expensive. Yeah. So
that's when Brad gets you. Brad's actually pretty good about figuring out how to get out of those scenarios. It's like, I can't say it's going to work, but this is the right things to file.
Yeah. This is what we'll try.
Yeah.
All right. Well, how about let's check out another myth.
Well, how about this one, Todd? The timeline.
All right.
The timeline of a lawsuit. Movies make it seem like, we just talked about I'll be in court next week. I think we kind of expand on that. Whereas it's definitely not going to be next week, and you're certainly not done with this lawsuit next month.
No, right.
It's going to be a year to year and a half minimum. The movies make it seem like it's so streamlined. I can guarantee if you're in Dallas, you will never, ever be streamlined.
Yeah, I guess the most common general civil litigation lawsuits, they're probably filed under what's called a level 2 discovery scheduling order, which dictates at least a 9-month process for the case. So at its best, you're looking at a 9-month process, but
and to be fair, that's 9 months after the initial disclosure.
Right.
So you're talking about the petition being filed, the deadline we talked about earlier for the answer to come in, then an additional 30 days after that for the initial disclosures, then 9 months.
So realistically, 11 months.
Yeah, you're already in 11 or 12 months right there. So,
and it doesn't take into account any backlog that the court might have, or something like that.
Or any kind of filings you did, like, hey, I'm calling, foul on this, and so we have to have a whole hearing about that. And that's just, again, it sucks, but that's just the true nature of the lawsuit. The movies really make it seem like it's so quick. It's not, and it's not for a reason, because if it was that quick, there'd be so many unfavorable rulings one way or the other. And that way, everybody, when the judge makes his or her decision, everything's been teased out, and I either believe you or I believe him based on everything you had a chance to discuss. That way, no one can claim, I get to add this. Yes, you did. You had this whole period of discovery. If you should have added it then, you don't get to add it now.
Yeah. And that's also why only about 1 or 2% of cases end up going to trial.
The settlement's so much better. I take the judge out of it, even better.
I've been shocked at how many cases actually settle on the eve of trial.
Yeah.
The day before, the morning of, or even at court.
Yeah, from a criminal side, I had it works the same way. You'll have plea bargains that are offered and everything, and sometimes you're just like, no, this is a crap case. I had one that and my client was a frequent flyer in the criminal justice system and everything, and
he just wanted to hang out with his homies every now and then in the jail.
He absolutely did something, but he didn't do what they said he did.
There you go.
So, but
you said he stole a Pepsi. That is clearly Coca-Cola. dismissed.
Well, so the thing was, so actually, he was accused of stealing a Sea-Doo watercraft with its trailer and some other stuff.
Can't blame him already.
Right. And so then I'm looking, at the offense report and everything, and I'm like, oh, it's like, I think they're probably pretty close on value here. I mean, it's a Sea-Doo watercraft after all, and it sounds great. And of course, this was in the 2000 somethings, after 2012 at least, and it was a 1993 model Sea-Doo watercraft,
but it was top of the line in '93
with no engine.
So this guy wasn't too bright.
Yeah, and then they didn't have the serial number, and so forth for the watercraft alleged in the indictment. They also were trying to say, and this was after some period of negotiation, because they were offering this. They had it as a third-degree felony. They were offering him 8 years because he was a frequent flyer.
Yeah.
And I was like, no, we're not doing that. We will plead to a Class B misdemeanor. is what I kept telling them. And they're like, no. And so it's like, whatever. Well,
Mr. Bond, you don't understand. I don't think you understand your charging papers here.
It's like, we might even plead to a Class A misdemeanor, but there's no way you're proving value. I was like, I've got a value problem, and among other things. And so, I probably represented that client for 18 months. And we finally came up to trial. The veneer panel was seated. I was at counsel table. He was next to me. The prosecutor comes and taps me on the shoulder, and we go back in the jury room. And they're like, "So we've got a value problem," and
and
a few other things. I was like, "I tried to tell you," and they're like, "So what about Class A misdemeanor, time served, no fine, deal."
Yep. Don't worry, he'll be back in a few months. He's going to do something else silly.
Yeah, the craziest situation I can think of similar to that is I went with Josh a while back on a case, a criminal case. This case was filed in Tarrant County, and it was filed at the onset of COVID. And so it took 3 or 4 years for the Tarrant County criminal courts to get their schedules back on track, and eventually this thing got set for trial, literally 3.5 years after the case was initiated. And some things came up, and it actually got continued twice. And so by the time we went to trial, I think this thing was about 4 years old. And by the time it was Josh's time to, go stand up in front of the judge literally didn't want to hear anything from anyone and just told the prosecutor, "Go out in the hallway and take this off my docket." And so
it was that bad.
It's a pretty serious case, and we ended up getting 6 months deferred.
That's awesome.
No big deal.
I don't think that's that shocking. Now, I did criminal law in Arizona, so I don't really know how it is in Texas, but
less math.
There, yeah.
Is there though?
Yeah, there definitely.
I don't know, but Brad tells stories about some of his clients it's a lot of math.
At least in the mid 2000s, it was all meth and identity theft. That's what you were dealing with. And meth heads stealing copper to pay for it.
Oh, yeah.
Those were your big
Gotta fund that habit.
But I was in Maricopa County, so I'm in the Phoenix area, and the prosecutors out there would always say, the first offer we give you is the best offer you're ever going to get. And it's true as you're going through the majority of the case. But as you get closer to trial, as I started practicing more, you would see that the week before trial, a day before trial, suddenly what was 7 years turns into 3. And I think that's a reality of the justice system, unfortunately, that a lot of people don't know. In my experience, it was because they were so backlogged. Mm-hmm. And usually they're not even paying attention to your case until the week of trial, maybe 2 weeks before trial. So there's a big push in the beginning of it. Oh, let's get them to sign this deal immediately. We'll offer 7, because they would have an offer on the table at your arraignment.
Mm-hmm.
Back then we would show up, they would have their little packet, you would meet with the prosecutor, we can make this go away with this deal today. Get arraigned, sign your deal. If you don't sign it then, the next deal we offer is going to be harsher. And it would be. You get into the middle of it, go through a little bit more discovery, talk to some detectives, the next deal, 10 years, whatever. But as you get to trial, and they suddenly have to pick up that file again and weigh your trial off. Right. Your trial versus the other 5 trials that prosecutor has coming up that month. Suddenly the deals get better. So a lot of times I would tell clients, just be patient. Let's wait. see what they're offering right before we get to trial. And you'd have situations just like you described. Usually they were a little better than right before. You guys called it voir dire here, right?
Voir dire.
Voir dire.
Voir dire. I'm sorry. I'm Texas, because
That's
we
the
know
proper
how to-
pronunciation.
Yes, sir.
Well, before whatever you
What
just
y'all call it in
called
Arizona?
voir dire.
Okay.
What you're supposed to. But yeah, usually you get a better deal right before trial, unless they've done something just egregious where they've decided he's going down. And I had a couple of
Or you
those.
catch another
Yeah.
charge.
Yeah. So
Those are my favorite.
I was fine. I sold meth. And you said you're handling. He's like, don't sell more meth, dude.
yeah, the I don't know, one of the best, plea deals that I was ever offered was on this guy. I got appointed to him in court, and you'll know Uncle Fester from the Addams Family.
Yes.
Like, my client literally looked like Uncle Fester, like the dark
Celebrity
circles
client,
around the
alright.
eyes, bald head, everything. And so I was like, okay, cool. I went back and talked to him for a little bit, and I was like, what are you here for? He was like, I'm here on an evading arrest charge. And it's like, okay, well, that's simple enough. So I went back to talk to the prosecutor, and it turns out it was a state jail felony possession under a gram and evading arrest, and then there's something else. I don't remember what the third charge was. I think it was resisting arrest. And so they said, we will dismiss all charges. And I was like, okay,
Great.
Went to the body cam first.
Do-
I know why.
do I sign now or what? And they said, no, you need to hear the rest. We will dismiss all charges if he tells us where the body is. My client was wanted, or suspected, I should say, not wanted. He was suspected of murder out of Lubbock County and everything, and had gotten picked up on these random charges in the county that I was in at the time, and in the missing girl's vehicle. So they're like, yeah, we just want to know where the body is, and
So we can add another charge.
Right.
So you're basically
Right.
incriminating yourself.
Yeah.
Oh, it's over there.
Incriminating
Thank
myself
you.
for murder.
Yeah.
So
So we'll let these misdemeanors go if we got murder on the table.
Right. So the thing is we do have an obligation to take offers to our client and let them know this is what they're saying, and so I did. I went to him. I was like, look, bro, they're saying they'll dismiss all of this if you just tell them where the body is, and he was like, what body? So that's not really what he said, but anyway, I'm not going to say what he said. But the thing is,
Latitude and longitude, right there.
right. But the thing is, I was like, that's freaking crazy. I ended up,
As your attorney, I advise you to not answer that question.
yeah.
Please do not answer that question.
No, I represented him for a little while, and then I'll just leave it with by saying that that situation handled itself.
Gotcha.
Well, let's chat about one other legal myth. I think this one's probably pretty relevant to everyone in this room's scope of work here at the firm, particularly everyone in this room. I guess Andrew touches a little bit of everything as an intake personnel here. But James and Brad in the civil department, what do you feel about this? The other side has to pay my attorney's fees if I win.
Well, the other side may have to pay your attorney's fees if you sued them under a certain statute that allows you to ask for them. The biggest misconception about that part, because there's another caveat, a statute, you have to sue under a certain statute and put it in your petition of why you think you're entitled to ask for attorney's fees. So if you win in the end, you have all these attorney's fees, say $100,000, long case, whatever. Well, you're entitled to ask for them, and then the judge has discretion whether he or she is going to grant them to you. And if they do grant them to you, how much of that? You can ask for the $100,000, and he's going to say, looks like 25 grand is actually reasonable. So you just cut it out, and the client just gets to be left holding the bag. It's like, well, you got a partial of it.
Yeah.
Yeah, well, what James is describing is what they call the American rule here, which is the theory that everybody should pay for their own attorney's fees. And that can be unfortunate. Part of the reasoning behind that is they don't want to give people more grounds to sue,
Yeah.
because I think people are already pretty litigious. But if you just guaranteed people that they would get their attorney's fees if they're just successful in their lawsuit, then people would be suing at an even higher rate, probably. So,
Isn't that how it works in Arizona then?
uh,
Well, for
it's-
majority, because I know you said like for some of it was like, no, if you sue for this, you know, if you prevail, you get it, or at least
Arizona
ask
has
for it.
something called, usually it's just the duty of good faith and fair dealing, which attaches to every contract and can be brought into a lot of different situations. It's still the same American rule in terms of it's not just the prevailing party who gets attorney's fees. There has to be a statute or a contract, but that duty of good faith and fair dealing provides for attorney's fees. So that's kind of the catch-all that people use to qualify for attorney's fees there. But the other issue is, and you sort of touched on this, it's the question of reasonableness, because it's not just your attorney's fees, whether you qualify for them, but the court has to determine whether they're reasonable. And that can depend on the judge. And
Yeah, because the reasonable factors can be like the time you spend on it, the amount it costs, and then they can even go back to, wait, you charge how much per hour for your services? Well, that's not reasonable.
Right.
And it's like, okay, now they just minimize it more and more because they're not looking to basically stick it to them unless that other party has just done nothing besides be, let's just say, not so nice in the entire lawsuit. And they're like, oh, no. You're going to get most of these. I just need you to prove them up just right. That way I can say, yep, and sign them.
Yeah. I didn't actually realize that the rule had a name, so that I learned something here.
I didn't either.
Yeah.
Ours
I might have just made that up.
No, ours is
section
section 30 of the Texas Civil Practice and Remedies Code. That's the usual one.
Right. In Texas has kind of adopted sort of a loser pays sort of approach on a lot of civil cases, but it does kind of depend upon what you're doing. You do still have to have the specific authorization in statute, the Civil Practice and Remedies Code, to get attorney fees. We on the intake side deal with this all the time. I mean, everybody wants the other side to pay their attorney fees. It's constant. What I tell people a lot of times is, on family cases in particular, I'm like, look, that's probably not going to happen.
Yeah, it'll be put in there.
Yeah,
but
we're going to ask for it as a matter of course because everybody does. But
the judge will go, pondered it now.
Yeah, but I will usually also explain, if you get attorney's fees, it's likely going to be in a situation where the other side is doing something to unnecessarily drag out the process. Right. Like if we have to file a motion to compel on discovery, or if we have to file a motion for enforcement because they're not following something in the temporary orders or something like that.
Straight up lie when we ask for sanctions.
Right. Then the judge is probably going to give you some amount of attorney fees for the extra work that has to be done to prepare for that particular hearing or to handle that particular issue. But it'll be $1,500 or $3,000 or whatever. It's not going to be whatever your entire bill. So I said you might get that, but we really kind of don't want to be in that situation. We want this case to move quickly and smoothly and so forth. We don't want to be in a situation of having it drag out. So it's kind of contradictory sort of things. But so otherwise, don't expect to get your attorney fees paid. But breach of contract is one where
I wouldn't say don't expect to. Just don't bank on it. Because it's a heavy swing, and the attorney could. I mean, as Brad and I kind of said, we can have it teed up and look, very pristine, very proper, and have all these arguments to show how it is reasonable and all this. The judge can still go, no. Right. It is up to the judge, and that's the part that sucks to have to tell them.
Well, and that's one of the things I say a lot of times in intake too. Is it's like, look, it's like, this comes in more along the lines of when people ask for a guaranteed outcome.
Right? Good golly.
Yeah, because it's like
we can get disbarred if we do that.
Right. Yeah, I mean that's the first thing I tell them. I say, look, the state bar in Texas doesn't allow us to guarantee outcomes, and the reason for that is because judges in the state of Texas have an incredible amount of discretion on most cases. So it's like you can go, and you can have a panel of 20 judges sitting in front of you, and they hear the exact same argument on the exact same facts at the exact same time, the exact same way. And then you send them back into 20 different rooms to come up with their ruling, and they're going to come back to you with 20 different opinions.
Right.
They go from you losing your shirt to you winning everything and everything in between. You
Yeah.
know, and so there's absolutely zero way that we can tell you what the outcome of it's going to be, because it just so much depends upon just the luck of the draw. And it comes down to the luck of in a county like Dallas or Collin or Tarrant, where you have multiple district courts and multiple county courts of law, and you don't get to pick. You know, it comes down to the random selection of which court's going to get that case. You know, and it can even, you know, there's going to be an outcome in Dallas County on similar facts that's not going to happen in Collin County, you know, for example. So it also kind of depends on where you're at. So it's just too many factors. But that's something that a lot of people ask about. But this goes to attorney fees as well, because it's not really an objective standard to determine what's a reasonable fee or not necessarily. It's kind of just up to the judge and what they think.
And most judges were lawyers, so they'll have their own opinion on what's reasonable, a reasonable hourly rate based on the
They see everybody
experience of the
every
attorney.
day. So yeah.
So they'll have their own bias in terms of if they think that number's too high for the kind of case that's been before them. So you have to deal with that too.
Yeah, I've seen it applied pretty differently with attorney fee affidavits. I've seen sometimes they will get approved or granted without invoices attached. You know, 50,000, just an affidavit, sure. And then I've seen exactly what you're saying. We'll provide invoices with an affidavit, and the judge will go through and mark out how much was billed based on, you know, that attorney or paralegal's experience level even.
Right.
So definitely.
Or the time that was dedicated to it. Oh, this isn't a reasonable amount of time.
Reviewed 6 pages, 8 hours. There's a lot of text on that, Judge.
Well, guys, I think we're going to wrap up episode 6. We'll be back next week, Thanksgiving week, with episode 7. Hope you enjoyed today's content. We'll see you next time.